Yo, what's up, fellas? What's up, fellas? It's gonna be a good podcast tonight. It's gonna be a good podcast tonight, fellas. Grab you a chair, get you a drink, fire you up a cigarette or a cigar if you smoke. All right, hold on just a second. Let some people come in here. We're gonna start in 4 minutes. I got to load up this the literature. Give me 4 minutes. So I'm gonna let y'all know y'all got more rights than what she do. Way more rights. Way more. That's why I'm gonna explain that. Hold on, let me see. Did it download? Yeah, it downloaded. Hold on, fellas. Man, ooh, this is awesome. There's some good stuff, fellas. Hold on. Doom, doom, doom. What's up? 2 more minutes. I want to see y'all. Let me know. Can y'all see this? Let me know. Can y'all see that? Can y'all see that? Let me know y'all can see that. We about to start in 30 seconds. I don't know what this little thing is for. Connection is unstable. Moving closer to it. Oh, okay. That's why. Mm, mm. All right, fellas. Well, let's start, fellas. Y'all fellas, remember this ain't legal advice. It's just man advice. Can y'all hear me? Turn up the volume a little bit. Y'all see what's on the screen, right? Title of this video, this live is Child's Custody. You have more rights than her. Remember that, fellas, you got more rights because you can protect, right? Private family choices, constitutional protection for the family and its members, evolution of the right to privacy. The Supreme Court has written often that family life belongs in a private realm. The state cannot enter. Y'all see that? I marked that for y'all. The Supreme Court has written often that family life belongs in a private realm. The state cannot enter. But how does the state enter? Who runs to the state? Huh? Who runs to the state? I want everybody to participate. Who runs to the state? She do, right? So who violated your right to privacy? She did. Okay? Let me go to the next page. Let me go to the next page. Let me know, can y'all see that? Can y'all see that? No, can y'all see that, man? By contrast, the wife was without any rights to care and custody of her minor children. By marriage, husband and wife became one person with the legal identity of the woman being totally merged with that of her husband. Okay, we're gonna stop right there, fellas. What y'all seeing that these dirty hoes is doing out right now? They get married to these cuck ass dudes. They'll have their last name and their name with a hyphen, right? Because these women know that these dudes are slow as hell, right? They know these niggas is slow as hell. That is disrespectful. That's all I've been seeing is a woman's name hyphen that she still got her maiden name, then she got your name hyphen. Huh? As a result, her rights were often subordinated to those of her husband, and she was laden with numerous marital disabilities. As far as any custodial rights were concerned, Blackstone stated that the law to be that the mother was entitled to no power over her children, but not only to reverence and respect. I'm gonna read that for you one more again because guess what? This law, that law over there has became that law over here. This law ain't went nowhere. Okay. But they know a lot of niggas is stupid. They don't read. They go with the flow. Uh-huh. Yes, man. We got all these yes men, right? I'm gonna read it one more time for y'all. Blackstone stated that the law to be that the mother was not entitled to no power over her children, but only to reverence and respect. Dudes, fellas, Blackstall commentaries on law of England. This is the law of England in this country. This law ain't been abolished. They want to add you into their law, but guess what? This shit is law, nigga. That's why they bring y'all ass to court and talk you out of your fucking rights. This is why they call you the child support court. Let's see this fool gonna sign his rights away and agree with every fucking thing that we say. Huh? By the middle of the 19th century, courts in England began to question and qualify the parental preference rule. It's a rule, nigga. It ain't a law. That's rule, nigga. Rules are made to be broken, but laws are to be followed. Was due in part to the hardships, not to say cruelty, inflicted upon unoffending mothers by a state of law which took little account of their claims or feelings. Are y'all reading along with this shit? Is anybody in the chat room? I can't see nothing. Hold on. You know how they trying to shadow ban this channel, boy. Hold on, let me go to my phone. Their feelings. See, I'm gonna tell you something. That's why they made up family court. Family court ain't number feelings court. Their feelings. See, I'm gonna tell you something. That's why it's a feelings court, man. Feelings. Their feelings. A treatise on law relating to custody of infants in cases of difference between parents or guardian, 1850. Courts reacted by taking a more moderate stance concerning child custody because they know niggas are stupid. They know niggas gonna pay, right? A stance which conditioned the father's absolute custodial rights upon his fitness as a parent. Now let me hit y'all with something. Did y'all take the fitness test? Did they find you unruly, unfit to have dominion over your child? Huh? I'm through with playing the theatrics with saying child in court, you award. Fuck all that shit. Fuck that dumb shit. Fuck all this. I'm a living man and I'm man. Fuck all that dumbass shit. You gotta drop your nuts. This is your child. Y'all had privacy, y'all home, banging each other out, making that baby. The court was not there. Ultimately, by a series of statutes culminating with Justice Torfor Act 2, fuck all that. Parliament affirmatively extended the rights of mothers, especially as concern the custody of young children. Justice Torfor Act expressly provided that the Chancery Courts in cases. Okay, check this out. Let me start right there. Chancery Court. What state has Chancery Courts? Ain't it New Jersey? In cases of divorce and separation, could award the custody of minor children to the mother if I'm gonna cut it off right there. I'm gonna cut it off right there. Y'all go back and watch this shit. I'm gonna cut it off right there. I'm gonna go back to the one people just showed here late. I'm gonna show them so this one more time what this says. The Supreme Court has has written often that the family life belongs in a private realm. The state cannot enter. Fellas, I'm gonna ask you a serious question. Have you ever told somebody to leave you alone? Huh? Have you ever told somebody, hey man, leave me out of whatever y'all got going on? You and her, y'all doing business together. Y'all gonna leave me out of it or somebody gonna get hurt. Have y'all ever said that? You reading? I'm giving it to y'all right here tonight. I'm giving it to you. I'm giving it to you. Private family choices, constitutional protection. Y'all rights already protected, but they want to know, do you know your rights? And if they violate these rights that you know, you can give them some lefts. Y'all hear me? Let me stop sharing it. Let me go to another one. Let me read y'all something. Y'all gonna like this. Excuse my dirty fingernails. Excuse my dirty fingernails. Can y'all see this? At conclusion of the case, this was the case. I only give this to the people who down with us. At the conclusion of the case, there did not exist a clear preponderance of evidence for either party regarding child custody. However, exists in Alabama law a presumption that when dealing with children of tender years, the natural mother is presumed, and tender years ain't nothing but a presumption, presumed in absence of evidence to the contrary, to be the proper person to be vested with custody of such children. The presumption, while perhaps weaker now than in the past, remains quite viable today. The sole issue presented for review is whether the trial court relies on the tender years presumption deprive the father of his constitutional entitlement to the equal protection of the law. At common law, it was the father rather than the mother who held a virtual absolute right to the custody of their minor children. This is for the niggas who ain't married. These is for us, fellas. We ain't married, right? And the dudes who are married, they have a little bit more leniency, but they listen to retarded people. We have more, fellas, we have more rights than the bitch. If the bitch can't take care of their child, number one, they violated your right to privacy, number one. Okay. Because they didn't ask you. And she didn't ask you. Okay. But anyway, the rule of law was fostered in part by feudalistic notions concerning the natural responsibility of the husband at common law. So we really common law husbands because we not in the courthouse's contract. Okay. The husband was considered the head or master of his family and such responsible for the care, maintenance, education, and religious training of his children. Let me read that again for you brothers in the back. The husband was considered what? The head or master of his family, and as such responsible for the care, maintenance, education, religious training of his children. It didn't say provide money, did it? It said care, nigga. Or it said pay. Did it say pay all the fucking bills? Did it say pay child support and what a bitch run take you to the wrangler? Did it say go to the child support courthouse? It's not saying none of that dumbass shit. By virtue of these responsibilities, the husband was given the corresponding entitlement to the beliefs of his children, i.e., their services and association. It is interesting to note that in many instances, these rights and privileges were considered dependent upon the recognized laws of nature and in accordance. And I'm going to cut it off right there. Y'all brothers have more rights than these women, than your baby mama or wife. They did not strike none of this shit down. This is still law today. But they do a background check on y'all to see if y'all gonna go in there and tell them and warn them to leave you alone and not to do it. Stay out of my business. I don't want you interfering. If they gave her right long time ago, if y'all go to some of these podcasts we did long time ago when the agency told her she has Fifth Amendment rights not to testify, to plead the fifth. But when you go in court, you can't do it. That's an equal protection violation, fellas. You see it right there? I told you it was gonna be good. And I told my brother up there on the West Coast, I told him it's gonna be a good one tonight. Don't be listening to these dumbass hoes on the sideline and these old pussy scary ass niggas on the sideline. They on the sideline for a reason, nigga. Real talk. I got that dirty nail on that screen. That means I ain't scared to get my motherfucking hands dirty, nigga. I don't know when dudes are gonna start invoking their power, invoking their rights, right? Let me stop sharing that. Let me stop sharing. God damn it. I told you it's gonna be a good short one. And I ain't finna hold y'all all fucking night long. But I just came to put something on y'all mind. Y'all have a good night. Peace.